Justice Alito?
To follow up on Justice Thomas's question, suppose that the FTC did not have the members, the commissioners did not serve 7-year terms, staggered 7-year terms. Suppose there was not the requirement that no more than 4 be members of a single political party. Suppose that they served very short terms. Why does it matter that it's a multi-member body as opposed to a single-member body in itself? What is significant about that?
The significance is the distinction for purposes of individual liberty, the threat that is posed to individual liberty by single-headed agencies that are not accountable to the president. That, as I understand it, Justice Alito, is the logic of this court's decision in seal of law, and we recognize that intelligent people of goodwill can disagree about that.
Seal of law didn't have to decide the question that's before us here. But suppose that there were 2 FTC commissioners and they served 1-year terms. And you would say, well, that's okay, but there's a difference between that and an agency that's headed by a single member.
Making the terms shorter, in my view, would not raise constitutional concerns because that would only increase presidential opportunities to influence the composition of the agency. Reducing the number of commissioners might be a different type of situation. I'm not aware of any 2-headed agency that has ever been created in the modern era or throughout American history.
Well, okay, what we're looking for are conceptual explanations for the distinctions you're drawing. But let me move on to something else. Suppose the Department of Justice were split into 2 parts. One part has the authority to enforce the criminal laws, and the other part has the authority to enforce civil laws. Could the civil component, could Congress put at the head of the civil component a multi-member commission with removal protection?
Justice Alito, there is the logically antecedent question with respect to any removal protection of whether Congress has constitutionally enumerated authority to enact the protection in the first place. And as has been suggested in prior colloquies, the relevant source of constitutional authority would appear to be the necessary and proper clause in terms of attaching removal restrictions to a federal office that is created by Congress. I don't think it's obvious that you would comply with all the strictures of the necessary and proper clause ex ante. And so it's not obvious that Congress could do that. And what we know for sure is that Congress has never tried to do that.
Well, I know you keep answering it hasn't been done and it's not going to be done in the future, but I want to understand the limits of the principle that you're asking us to accept. So you cannot say, no, that would not be permitted for this reason. Well, the best you can say is that it might not be necessary and proper.
If you wanted, that is one source of limiting principle for sure. But also, our argument is predicated in part on a long historical tradition pertaining to what are called—
Okay, I understand the historical argument. That wasn't what my question was getting at. All of the civil enforcement laws, all of the civil laws that are now enforced by the Department of Justice were enacted by Congress under one of its enumerated powers. Let's assume that they were all constitutional. So the question is whether it would be necessary and proper to the enforcement of those given the understanding of necessary and proper, to entrust that to a multi-member commission as opposed to a single officer like the Attorney General? That would be the question.
I don't think so. And what I was trying to get at before is not just that there's an historical tradition, it's that the historical tradition we're invoking is for what are called traditional multi-member regulatory commissions. And those historically have never involved just purely executive civil enforcement. They involve a blend of lawmaking, adjudicatory, and enforcement actions where the enforcement authority is deemed to be reasonably ancillary to the other functions. So the kind of hypothetical that you're positing, Justice Alito, I think it's an absolutely legitimate concern, but the historical tradition that we are drawing on for purposes of our constitutional liquidation argument would not require you to affirm the constitutionality of that kind of highly unusual structure that, as far as I know, has never been attempted before.
On the question of giving the members of a multi-member commission longer terms of office. So here we have 7 years. What if it were increased to 10 years? What if it were increased to 15 years, and so forth? And the principle that you would have us apply is whether that longer term of office preserved adequate presidential supervision. Is that your answer to the question?
That is one potential limiting principle.
We would have to, in each of those, in every case in which that would be involved, we would have to determine, do I think this preserves adequate presidential supervision?
Our primary submission to you, Justice Alito, would be that it would not be the burden of the court to develop ahead of time heavy-handed constitutional rules that would try to make constitutional distinctions between, say, a 7-year term and a 9-year term or an 11-year term. Those don't appear to us to be distinctions of constitutional proportions. Members of the Federal Reserve do have substantially longer terms than, say, FTC commissioners, and nevertheless, petitioners don't seem to have a problem with members of the Federal Reserve enjoying statutory removal protections. But our position is that the court should recognize that these are really difficult line drawing problems, and the way that that has historically been resolved is through the political process, and the political process is up to the task of dealing with this problem.
But you wouldn't say that we leave it complete. Would you say we leave it completely to the political process?
No,
so that at no point in the extension of these terms would we say, oh, there's a problem. I thought you were saying there is a test. And it is whether there's adequate presidential supervision. And if that were challenged, we would have to decide. We would have to exercise our judgment about how much presidential supervision is necessary to satisfy constitutional requirements.
Absolutely. The court should not relinquish its authority to establish judicially enforceable outer boundaries in this context. I just don't think that you're going to have to do that anytime soon, and you might never have to do it, but you should absolutely not relinquish your authority to do it. And there could be hypothetical scenarios in the future in which there's an arrangement that just palpably does not guarantee adequate presidential supervision, but that hypothetical risk, again, has to be measured against the real-world chaos and disruption that will be caused by taking—
Okay, one other question about where your argument would lead. So to go back to this issue of the various departments and whether it would be permissible for Congress to convert them into agencies headed by multi-member commissioners, by multi-member commissions with the members protected from plenary presidential removal authority, the test would be whether some limit on permissible, limit on exclusive and preclusive activities was exceeded.
Our primary—
Do they go to, if they're exercising any power that is exclusively and conclusively the president's, are they exercising too much of that? That would be the test in going through these departments?
No. I think if they're exercising any power that is conclusive and preclusive, then you have a separation of powers problem. That's the solution to which is not necessarily to strike down the entire agency or even to eliminate the for-cause removal provision. It creates an analytically distinct issue about how you remedy that violation. But I think any conclusive and preclusive power that is vested in an agency that is not sufficiently accountable to the president is a problem.
Okay, I thought you had answered, in answer to a prior question, you said a mere scintilla would not be enough, but now you say a mere scintilla would be enough to cause a problem.
I may have misspoken before, Justice Alito, and if I did, I apologize, but our position is that if a multi-member agency is vested with the president's conclusive and preclusive powers and it is insulated from at-will presidential supervision, that is a separation of powers problem.
It does 200 things, and one of the 200 things involves the exercise of an exclusive and conclusive presidential power. That would be too much.
That would be too much with respect to that power, but maybe the solution to that is to sever out that power and not to strike down the entire agency.
Thank you.